When most people describe to me what they believe their will does, their last will and testament, it is usually an explanation of what a living revocable trust would do. Very odd, but it's true. Inside of a will, you have things that are owned by yourself, not things that are owned by you and your spouse, not things that have beneficiary designations, not things that have predetermined transfer things like payable on death or transfer on death attached. What goes to your will is stuff that is in your name and your name alone. And it is a legal document that says, here's what I want to have happen to what I have left over that is in my name and my name alone. You have an executor. They're in charge of administering everything that's done when you're gone. Now, many people have understood and learned that there's challenges with wills. First of all, most assets are owned by a spouse. Most retirement plans do have a beneficiary. And in fairness, very few things actually make it to a will. Regardless of what's in the will, it may not happen. When I was young and kind of rambunctious, I had a will that gave my mom the Eiffel Tower, my brother the Bears, and my dad the Cubs, just to prove that what you put in a will doesn't matter. If you don't own it, you can't give it. And most things that people have are not assets that are owned in their own name and only their name. A trust, on the other hand, is a legal document where you have a trustee. That's typically the person who put the assets in as the original trustee, what we call the grantor. And then you have successor trustees who are in charge. And this really is a very, very important difference that I think people need to understand. Now, you need to keep in mind, I'm not an attorney. I am an educator, a financial professional. All of that is true, but I'm not an attorney. I have one on my team. I have a partner that's an attorney. So don't take this as legal advice. What I try to do is give you ways to understand and think about things. So things that are outside of my trust, when I need somebody else to sign my name, like my wife or my kids or my attorney or whomever, I get a power of attorney document. And that extends to them the authority to sign my name. You need to understand that it doesn't remove my ability to sign my name. It merely extends that ability for them to sign my name. So if there's a sale of a property or a healthcare decision that has to be made, somebody can sign it as POA. When you move inside of a trust, you are either the trustee or you're not. So it's an either or situation. And in the world of a trust, if your successor trustees have been elevated to the position of trustee, there is no power of attorney. The trustee, whomever that happens to be at the time, is the one now in charge making the decisions. A will go through probate, not a tax that's paid to the government, but a legal expense that's paid to attorneys in the courts. A trust and assets held inside of the trust avoid probate. So there's many reasons to use a trust instead of a will. Privacy, the expediency, the ability to be able to get it done, some control. There are people who will tell you that a trust reduces federal estate taxes. I will tell you it's a better tool than a will, but it doesn't by itself do that in any way, shape, or form. But it does give me privacy. It does give me the ability to make some better decisions into the future. It does protect my assets for some complications that we don't have time to discuss today. But there are key differences. And so people will say, so Joe, you don't have a will? I didn't say that. I have a will, but the will is called a pour-over will, and it merely says anything that I forgot to put in my trust, please do. My trust dictates how I want my assets cared for while I'm still here and when I'm gone. How my wife and my children are able to spend the money in future years and how I'm taken care of while I'm still here.